The phone rang 3 weeks after the funeral. Not from family, not from a friend, from someone she had never heard of. He introduced himself as a financial advisor, said he specialized in helping widows rebuild after loss, said he had reviewed her situation and had some ideas that could protect her. She didn't remember signing up for anything. She didn't remember giving anyone her number. But he seemed to know things. Details about her finances. So she listened. What she didn't know, what most people in her situation never know, is that 3 weeks earlier, when the estate was formally filed with the court, her financial picture had quietly become part of the public record. Not her account passwords, not her social security number, but enough. Enough for the wrong kind of person to build a picture. This is a story about how that happens, why it keeps happening, and what you can do right now to make sure it doesn't happen to you or someone you love. What exactly becomes public? Who is accessing it? How do they find widows so fast?
Most people assume that their financial life is private. Their account balances, their investment totals, the general shape of what they have built over a lifetime. And in most circumstances, that assumption is correct. But probate changes the equation. Probate is the legal process that governs what happens after someone dies. When a person passes away with a will, that will is typically filed with the probate court. In most states, that filing becomes a matter of public record, accessible, searchable, in some jurisdictions, viewable online. And wills don't just say who gets what. They can describe asset categories, reference account types, mention specific financial institutions, provide a general picture of the estate's value.
Estate inventories, documents that detail what the deceased owned, are often required by the court as part of the settlement process. In many states, those inventories become part of the public file. Not every piece of information, not account numbers, but enough. Enough for someone who knows how to read these documents to understand this widow has substantial retirement savings. This person is financially exposed. This person might be worth a phone call. How often does this actually lead to fraud? Let's look at the numbers. According to the Federal Trade Commission, older adults, those 60 and above, reported losing more than $1.8 billion to fraud in 2023. That estimate is believed to significantly undercount actual losses because the majority of elder fraud cases are never reported at all. The National Council on Aging estimates that financial exploitation of older adults costs between $2 billion and $36 billion annually when all forms of exploitation are included, a range that reflects how systematically undercounted this problem is. And probate-related exposure is a documented entry point. It is not the only one, but it is one that almost no one thinks about until it is too late.
Most people think the danger comes from hackers or strangers online, but some of the most targeted moments come from completely legal, completely public government processes that happen in every county courthouse in America. The information may not reveal everything, but it can reveal enough to attract attention from people looking for opportunity, vulnerability, or both. And by the time most families realize how visible those records can be, the probate process is already underway. When a will is filed at the courthouse, who actually sees it? Court clerks? Attorneys handling the estate? Family members? That's what most people picture. But court records in most states are public, and they are increasingly searchable, which means the universe of people who can access this information is much larger than most families realize. Financial predators, including some operating under the appearance of legitimate financial services, have been documented monitoring probate filings to identify newly widowed individuals with apparent assets. The goal is to make contact quickly, while grief is fresh and defenses are low, and to position themselves as helpful before the person has time to build proper protection.
This isn't speculation. The FBI, the FTC, and state attorneys general have published consumer alerts specifically about financial targeting that occurs in the weeks following a spouse's death. It isn't always someone who seems obviously dangerous. Sometimes it's a caller who sounds professional, knowledgeable, and compassionate. Sometimes it's a mailer that arrives on official-looking letterhead. Sometimes it's someone who says they knew the deceased and have been meaning to reach out. The common thread isn't how they appear. It's the timing, and the fact that they seem to know things they shouldn't have known. Now, let's make this real. Let's follow Dorothy. We're about to see exactly how this plays out in real life through a fictional case study.
Meet Dorothy Simmons, 71 years old, retired school teacher from the Midwest. Dorothy and her husband Raymond had been married for 44 years. Raymond died after a brief illness. He had a will. The family hired an attorney. The estate was small but organized. A home, 2 retirement accounts, some savings. The attorney filed the will with the probate court 6 weeks after Raymond's death. Dorothy didn't attend the filing. She was at home, trying to figure out what life looked like now. 3 weeks after the filing, the calls started. First one, then another. A different name each time, but the same general shape. Financial professionals, expressing condolences, offering help. One caller mentioned the name of the financial institution Raymond had used. Dorothy didn't remember sharing that anywhere publicly, but it was in the estate inventory. One caller referenced the approximate value of Raymond's retirement account. Not exactly, but close enough to be unsettling. It was in the estate inventory. One sent a letter to the house. He had the right address. It was a matter of public record.
Dorothy was not naive. She was a retired teacher. She asked questions. She hung up on callers who pressed too hard. She mentioned the calls to her daughter. But she also had a moment. One moment where the caller sounded legitimate enough and she was tired enough and the loneliness was heavy enough that she almost agreed to a consultation. She didn't. Her daughter called back the number and it went to a voicemail box that had been disconnected. Dorothy got lucky. Most people in her situation don't know they got lucky. They find out months later when the account statement doesn't look right. Dorothy's story is not unusual. What's unusual is that she told someone. Most widows and widowers navigate this period in silence, too overwhelmed by grief to recognize what is happening. Stop here for a moment. If you are watching this and you have recently lost a spouse, or you are planning an estate right now, or you are helping a parent through the settlement process, what you just heard matters. Because what comes next is where most people make the decisions that cost them. Here's the honest question. What actually stays private and what doesn't? Because the picture is more nuanced than most people realize, and there are specific, practical tools that can reduce your exposure if you know they exist before you need them. What specific legal and financial tools keep your information out of the public record? Not everything goes through probate. Understanding the difference is one of the most practical things a retiree can know. Assets that typically pass through probate, and therefore may become part of a public court filing, include assets left in a will with no named beneficiary, certain individually held bank accounts and investment accounts, and personal property explicitly named in the estate. Assets that typically bypass probate entirely include retirement accounts, such as IRA accounts and 401k accounts, because these pass directly to named beneficiaries and are not subject to the probate process. Life insurance policies with named beneficiaries, jointly held property with right of survivorship, accounts that have transfer on death or payable on death designations, and assets held inside a properly structured revocable living trust. This matters enormously, because if your primary assets are structured to bypass probate, there is dramatically less to expose in a public court filing. Many retirees don't realize that the beneficiary designation on a retirement account, that form you filled out when you opened the account, is one of the most powerful privacy tools they already have. When kept current, it means that account moves to the designated beneficiary directly with no probate court involvement. Most people think estate planning is about deciding who gets what. It is also about controlling what becomes public and what doesn't. Those are two very different conversations.
Here are 5 concrete steps that can reduce your financial exposure when an estate is settled. Step 1. Review your beneficiary designations right now. Every retirement account, every life insurance policy, every account that offers a transfer on death option. These designations override your will. If they are outdated, if they still name a deceased spouse or a former relationship, update them immediately. An out-of-date beneficiary designation is one of the most expensive estate mistakes retirees make. Step 2. Have a conversation with an estate attorney about a revocable living trust. A properly structured trust can allow your assets to bypass probate court entirely, which means they do not become part of any public filing. The cost of establishing a trust is modest compared to the protection it provides. Step 3. After a spouse's death, establish a waiting period before accepting any new financial relationships. Consumer protection agencies recommend at minimum a 60 to 90-day window. Any financial professional who pressures you to make decisions quickly during the grief period is not looking out for your interests. Step 4. Know the red flags. An unsolicited contact who references your specific financial situation, your account balances, or your deceased spouse's accounts without a prior established relationship should be treated as a warning sign, not a starting point for a conversation. Step 5. Tell someone. Designate a trusted family member or friend as a second voice on any significant financial decision made in the 12 months following a major life event. Not someone who controls your money, someone who knows to ask questions. These are not complicated steps, but almost none of them happen automatically. They require intention, and the best time to put them in place is before there is an estate to settle. Dorothy still gets calls. She probably will for a while. But she talked to her daughter. She talked to her attorney. She updated her beneficiary designations, something Raymond had meant to do but never got around to. She started the conversation about a trust. She knows now that what happened was predictable, that the system works a certain way, that the people who called her weren't necessarily criminals in every case. Some were just aggressive salespeople fishing from a public pond. But some of the numbers they had shouldn't have been as easy to find as they were. The uncomfortable truth is that financial privacy in retirement requires active management. It doesn't protect itself. And the moments when that protection matters most, the weeks after a death, the period during a major life transition, are also the moments when your defenses are at their lowest. The good news is this. You now know something Dorothy didn't know before the call started. You know how the system works. You know what gets filed. You know what gets exposed. And you know what to do about it. That knowledge doesn't cost anything. But what you do with it, that's worth protecting. Take the steps. Update the designations. Have the conversation. Don't wait for an estate to teach you this the hard way. Retire smart and not sorry. How many people right now have financial information in the public record that they don't know about? The answer might surprise you more than anything else in this video.